I'll be cheering on Rutgers for you next week.
Uh-oh.
Wow. Now wait till he gets out of camera view and then take him down in the hall. No. Take care.
Right from the start, you can feel the tension in this courtroom. What looks like a routine court appearance quickly turns into something far more dramatic. The judge is already watching the behavior of the people in front of him very closely, and it becomes clear that patience is going to be very limited today. In this hearing, we're about to see multiple defendants, legal confusion, and a judge who isn't afraid to call things exactly as he sees them. One defendant claims she has hired a lawyer at the last minute, while another is preparing to challenge his own attorney in court. These moments might seem small, but in a courtroom setting, they can completely change the direction of a case. So, the real question is this: are these defendants helping their situation, or making things worse for themselves right in front of the judge?
Wow. Really nice guy till that. Court does call the case. People State of Michigan versus Chloe Whitsett.
Edward Ricks on behalf of Chloe Whitsett.
Oh, Chloe Whitsett.
Okay.
Your Honor, today's the time of day set for probable cause conference. We adjourned last time for her to obtain counsel. My update from last time is she does report to me that she did obtain counsel and would plan to have them here at the next hearing. On her behalf, I'd ask for an adjournment.
Counsel approach. Counsel approach. Ma'am, have you retained other counsel? I think you indicated that the last time.
Yes, I have. But it was very last minute when I paid them. And again, the counsel that I have retained, I really did not want to say the name of the Perkins group, but the attorney is either a representative directly of the Todd Russell Perkins group or a referral from him, because like I said, this is a favor. I was telling him that it's a favor to me. He's not even charging me what he charges normal people. I didn't even give him what.
Okay, I don't need to know all of that.
Yeah, well, I'm just saying
But
yes,
what I'm going to do is I'll adjourn this out 2 weeks to the 25th at 9 a.m. or your time that's set by the court.
That's fine. That's enough time.
And ma'am, the last time that you were here, we had a problem, and I'm just going to call it what is your attitude or somewhat your demeanor. And
This is a very important moment in the hearing. The judge is addressing the defendant directly about her behavior outside the courtroom, specifically the emails she has been sending to the Department of Community Corrections. In legal terms, this matters more than people realize. When someone is out on bond or under supervision, communication with court authorities usually has strict rules. Going around those rules, especially by sending repeated messages or what the court considers harassment, can actually violate the conditions of release, and the judge makes that crystal clear here. Notice the warning he gives. If this behavior continues, her bond could be revoked. That means she could be taken into custody immediately and held in jail while the case continues. So here's the question for you watching. Do you think the judge is being too strict here? Or is this exactly the kind of courtroom control that's necessary to keep the legal process running smoothly?
I thought we were straight when you left, but you're sending what at least people are considering harassing emails to the Department of Community Corrections.
Mm-hmm.
So what I'm saying is community corrections outside of what's required.
That's what I'm asking. I'm driving.
I think what she's
What can it be modified is what I'm saying. Because
right now, they're not going to modify it. You can ask to modify it the next court date.
okay, yes, I have. They will.
Ma'am, I don't want, there is no reason for you to be emailing them.
Well, they were,
No,
no, sir, no communications.
They
Other than
call
to
you,
drop.
you talk to them, that's it. But
Yes, sir.
this stuff, I don't know why you're trying to do this. Because this is just, you almost got yourself locked up the last time that you were here by me. And finally, you got yourself calmed down. I passed it because I didn't know what was bothering you. I passed it. When you left the podium and you left my courtroom, I thought we were all on the same page about how people should be treated and how we were going to do everything. And then I get here now and I get this. So I'm just going to tell you, I don't want anything improper. If you've got an attorney and you've got to, for whatever reason, express something or communicate, tell your attorney and have them communicate with community corrections. I'm just going to give you this admonition. If I get something like this again, I'm likely going to revoke your bond. Did you hear me, ma'am?
Yes, sir.
All right. I just don't want to see it. There's no reason for it. See you on the 25th. Bond will continue.
Thank you, Your Honor.
Public Defender Jay Bellinger on behalf of Mr. Belcher, who stands to my right. Mr. Belcher, will you please state your name for the record?
I am Thomas Ryan Belcher.
Thank you.
I would also like to fire my public defender, please,
Okay.
at this time.
Why is that?
I don't feel he's giving me proper reputation.
Okay. In what way?
He's not giving me proper reputation. He wants to adjourn it, and I've asked him not to. He won't come to see me and talk about my case at all. So
Now the focus shifts to a completely different issue, a defendant trying to fire his own public defender. And this happens more often than you might think in criminal courtrooms. Many defendants believe that replacing their lawyer will instantly improve their situation, but the reality is far more complicated. Public defenders are assigned by the court, and simply saying you don't like your lawyer isn't usually enough for a judge to remove them. The court needs a legitimate legal reason, such as a conflict of interest or serious breakdown in communication. Here, the judge clearly believes the attorney is actually trying to protect the defendant by delaying the preliminary exam until all the evidence known as discovery is available. Without that information, the defense would be walking into court unprepared. The judge even throws in a bit of sarcasm, reminding the defendant that legal strategy should probably be handled by the lawyer, not someone without a law degree. It's a moment that perfectly shows the tension between legal expertise and a defendant's frustration.
Nobody's talked to you about your case?
a couple of times, but
Oh, yeah, okay.
I just don't feel he's fit for to represent me at this time.
Really?
Yes, sir.
Oh, that's the only objection you have?
At this moment, yes.
And it's just him? Well, it's an office that is representing you.
I understand that. I've asked him not to have it adjourned, and he's trying to have it adjourned.
Okay, so you want it set for a prelim?
I would like that. Yes, sir.
Okay, is all the discovery complete, counsel?
No, Your Honor.
So you want to go to prelim without all the discovery being in and not knowing everything?
I
that
also
what you're
would like a
telling
new
me?
public defender too. This
What?
time.
Well, you'll have to deal with their office regarding that, but he's here. He's qualified, he's representing you. He's trying to actually protect your interests by not setting the exam where he doesn't have all of the information to be able to adequately discuss it. But I presume with your law degree, you decide you want to do it some other way.
I actually do not have one.
Yeah, that's what I thought. Kind of knew that. That's why you should probably let him handle it. Did you want to see all your discovery or you just want to go to exam?
I would like to see it.
What?
I would like to see the discovery.
Okay, so the only way that's going to happen is by following exactly what counsel wants to have happen to adjourn it so he can get it all, sit down and talk with you. Does that make sense?
It does, yes.
Yeah, it sounds probably the same thing he said to you. You'll just take it from me, but you won't take it from him. That makes no sense. Instead of talking, you ought to start listening. Your motion to fire counsel is denied. Counsel, you want an adjournment?
Your Honor, we would just be asking for 2 weeks. There's an investigation finishing up in our division.
April 25th, 2024, 9 a.m. so that you can get all of the information and talk to your accountant until you're fine. Thank you. Bond continued.
Was there a finding on competency?
Oh, actually, I believe
There
there
is.
was. Thank you
Bring him
for bringing
back.
that up.
I just want to make sure before we.
No,
I don't know that, did we do the finding? I thought we had.
If you did.
No, we did not.
No, it's okay. It's not your fault.
The report indicates that he's competent.
And Your Honor, we have reviewed that. I
But
do
they
have
didn't hear what happened today. But anyway, never mind. Go ahead.
we've been able to review that, have given Mr. Belcher a copy of that as well. We would stipulate to the findings.
People also stipulate to the finding. Defendant is found competent to stand trial in this matter. Court specifically would indicate that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense.
By the end of this hearing, the judge has made several important decisions that shape what happens next. The defendant accused of sending those emails receives a very clear warning. Any further improper communication could lead to her bond being revoked. That's a serious consequence that could land her back in custody before the case even reaches trial. Meanwhile, the second defendant's attempt to fire his public defender is firmly denied. The judge explains that the attorney is actually acting in the defendant's best interest by requesting more time to gather evidence and prepare the defense properly. In other words, rushing into court without all the facts could seriously damage the case. Finally, the court confirms that the defendant is legally competent to stand trial, meaning he understands the charges and can assist in his own defense. That clears the path for the case to move forward at the next scheduled hearing. Moments like these show how much courtroom outcomes can depend not just on the charges, but on behavior, preparation, and respect for the legal process. And now we want to hear from you. Do you think the judge handled this situation fairly, or do you think the defendants were being treated too harshly? If you found this case as fascinating as we did, make sure to hit the like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real legal drama.
Therefore, the defendant is deemed competent. Counsel, please file an order, and I'll set the probable cause for the time that I set on the 25th. Bond continued. Thank you.
Honor. And Assistant Public Defender Jay Bonjo on behalf of Mr. Cyrus, who stands to my right. Mr. Cyrus, can you please state your name for the record?
Yusuf Cyrus.
You want to fire him too?
No,
Okay, all right. I just thought I started out trying to figure out what's going on. Go ahead.
We're good, right?
good.
Your Honor, we
If he had said yes, I would have said, wow. Anyway, go ahead.